What's the Church of Scientology so afraid of?
This is SPTV.
Welcome back, everybody, for more SPTV, where every day is a great day not to be in a cult. We do have some new news in the trafficking lawsuit against David Miscavige and Scientology. David Miscavige is named personally in this suit, and he has been served in this suit. The last video that I did on this, if I even did a video on this development, there was a development in this case months ago, where the Judge Thomas Barber, this is the federal district court out of Tampa, Judge Thomas Barber had issued an order ruling that this lawsuit was not going to be able to move forward in the courts, and that the three plaintiffs in this lawsuit, three former Sea Org members, Valeska Paris, Gawain Baxter, and Laura Baxter, were going to be forced to undergo Scientology's internal religious arbitration. And it was clear in Judge Barber's order that he regretted having to make this decision, but based on the case law he was allowed to refer to, it seemed to him that the correct interpretation of the law, even if it was unfortunate, was that these three plaintiffs were going to have to be stripped of their right to bring this lawsuit in the courts and have their case heard by a jury, and that they were going to be forced to undergo Scientology's internal religious arbitration. Now, when I say Scientology internal religious arbitration, you might get the idea, oh, that's really a thing? No, it's not really a thing. It's something Scientology completely invented just to prevent themselves from being sued. There's no such thing as a religious arbitration in Scientology. L. Ron Hubbard never wrote anything about it. There's no policies and procedures for how such a thing should occur. One of these had never even been held in the history of Scientology until a few years ago, when Scientology was forced to invent a procedure and hold one for the first time because they were being sued by Luis Garcia and his wife Rocio Garcia. And Scientology was forced to admit that they'd never held one before. And then the court asked Scientology, well, what's the procedure for this thing? And they're like, and they pulled something out of their butts where they said, oh, the procedure for the religious arbitration is in accordance with the policy letters in Scientology for the procedure of what Scientology calls a committee of evidence. Now, a committee of evidence is a real procedure in Scientology, but it has nothing in common with an arbitration. Anyhow, Scientology's been basically playing games with the courts, because the courts are, to a certain extent, their hands are tied to a certain extent on how much they can wade into religious policy and procedure. And Scientology's been taking full advantage of that. In response to this ruling by Judge Thomas Barber, the plaintiffs' counsel submitted a request to the court saying, now, hold on. We would like to be able to appeal this specific ruling, even though this case is not over, because Judge Thomas Barber put the entire case on hold pending the completion of the religious arbitration. Technically, you're not allowed to appeal something until there's a final ruling and the case is over. There's nothing to appeal. But in matters where a certain issue or decision or order has been arrived at, and it's an order that could easily be argued with, like it's not clear cut. The decision was not arrived at easily. There is something called an interlocutory appeal, where you can ask the court to go, hold on, can you please rule that we are allowed to ask the appellate court to review this specific decision now instead of waiting until later? And that is exactly what the plaintiff's counsel did. The court, I'll use that interchangeably, agreed to certify that decision as eligible for appeal. And the plaintiff's counsel has now officially submitted their appeal to the 11th Circuit Court of Appeals to overrule, requesting them to overrule this decision that this lawsuit cannot move forward, and to overrule the decision that the plaintiffs have to undergo the incredibly abusive process of the quote unquote so-called internal religious arbitration. That's the headline. That's the summary. I do have two legal documents that I want to share portions of you with, because they're legal documents, and because I'm doing this live, it is a little tedious. I've already reviewed the documents. I know which portions I want to share with you. But that's why I wanted to begin by giving you guys the headline. If that's all you wanted and you wanted to tap out on this video, feel free. If you want to see some of the really interesting language in two of these documents here. Stick with me. I'm going to show you some stuff. Okay, this is the this is the order granting in part and denying in part plaintiffs' motion to certify the court's March 31st, 2023 order for interlocutory appeal under. I don't like reading all those letters and numbers, so we're gonna skip that. This matter is before the court. This matter is before the court on plaintiffs' motion to certify the court's March 31st, 2023 order for interlocutory appeal. And on May 12th, 2023, defendants filed a combined response in opposition. Upon review of the motion, response, court file, and record, the court finds as follows. All right, I told you guys this was going to be a little tedious. I'm going to read for you some of this information here. Plaintiffs are former members of the Church of Scientology. They were introduced to Scientology as children by their parents, and they remained active in Scientology as adults. As practicing Scientologists, they served for over a decade as members of the Sea organization, which is described as a religious order within the larger Scientology religion. Plaintiffs bring this action pursuant to the Trafficking Victims Protection Reauthorization Act, alleging that defendants coerced persons, including plaintiffs, to join the Sea Org and provide unpaid labor and services on a 10,328-ton cruise ship vessel known as the Freewinds, where defendants knowingly obtained valuable benefits, including financial enrichment. Plaintiffs allege that Freewinds frequently sailed to nations where anti-trafficking measures were weak to avoid legal repercussions, and it has never docked at any port in the United States or even entered the territorial waters of the United States. I can tell you guys, let me switch views here. The Freewinds not entering the territorial waters of the United States is, without question, 100% intentional. And this is a quick little message to you under the radar Scientologists out there, or any of you actual still real Scientologists who've never thought this through for a moment. Think for a second as to why the Freewinds ship even exists. Think for a second about Scientology's claims that the reason the Freewinds even exists is that in order to obtain the full spiritual benefits of OT8, you have to go to the ship and do OT8 off of the comm lines of the world. You basically have to do it in an environment where there's no influence or upset. Word Scientologists would use is interbulation or merchants of fear, merchants of chaos. You have to do it in an environment that is so free from the destructive influences of the forces at play on Earth that you got to do it on a ship in the middle of the ocean. Now think for a second that the Freewinds, if you go to the Freewinds right now, you are not in the middle of the ocean. You are tied up at a dock in Aruba or Curacao. The Freewinds just sails back and forth between these two islands and just sits there at a dock. There's no difference between going to the Freewinds and sitting at dock, tied up to the dock in Aruba or Curacao, or going to the Freewinds if it was tied up at one of the harbors or whatever in Tampa Bay. There's no reason in the world to go to the Freewinds ship. There's no reason in the world for the Freewinds ship to be in Aruba or Curacao. It's incredibly inconvenient. It's expensive. You have to fly to go there. Why? There's no reason for OT8 to be done on the ship. OT8 could be done at Flag. There is a reason why Scientology wants to have a ship outside of the territorial waters of the United States. Just think about it for a little bit, you Scientologists out there. Okay, so let's fast forward to some other stuff in here. Plaintiffs allege they were forced by their parents to join the Church of Scientology as children, where they were indoctrinated, manipulated, and pressured into coercive circumstances from a young age. They now contend that Scientology was a world filled with abuse, violence, intimidation, and fear. For a time, plaintiffs were assigned to work on Freewinds under highly dangerous and abusive conditions, often working between 16 to 24 hours a day. In the amended complaint, plaintiffs detail numerous instances of punishment, humiliation, interrogation, and imprisonment occurred while they were members of the Sea Org, including various acts of mental, physical, and emotional abuse. Okay, we're going to fast forward. Okay, on March 31st, 2023, the court entered an order compelling arbitration and staying the case pending arbitration. That's what I meant earlier when I said the case was kind of put on hold. It has been stayed. Plaintiffs now request that the court certify its decision compelling arbitration for interlocutory appeal and seek clarification. Defendants oppose the motion. Now, this is where it gets really interesting in some of the legalese, and this is why I really actually wanted to do this video to get a little bit more into the weeds on on what it means that the judge has acknowledged that this is an appropriate circumstance for interlocutory appeal. To me, it's very, very interesting. I'm hoping it's interesting to you guys as well. Okay. Interlocutory appeals are designed specifically to resolve abstract legal issues or issues of pure law. When a district judge, in making a civil action an order not otherwise appealable under this section, I'm sorry, let me reread this. When a district judge, in making, I'm getting confused here. When a district judge, in making in a civil action an order not otherwise appealable under this section, shall be of the opinion that such order involves 1, a controlling question of law, and 2, as to which there is substantial ground for difference of opinion, and 3, that an immediate appeal from the order may materially advance the ultimate termination of the litigation, he shall so state in writing in such order. The party seeking the appeal bears the burden to establish that it has met all 3 elements. Okay. The judge has basically agreed that all 3 of those standards have been met. So plaintiffs request that the court certify 2 questions for interlocutory review. 1, whether plaintiffs' fraud in the execution challenge and duress challenge to the arbitration agreements must be heard by a Scientology arbitrator rather than the district court. And 2, whether forcing plaintiffs to participate in a Scientology religious arbitration violates their First Amendment right to leave their religion. Now, this is really interesting because Scientology claims that the internal religious arbitration is a religious ritual. That's really strange to me. They claim, and they make this claim partially based on the fact that they have just come up with this lie that the procedure for the arbitration is the same as a procedure for a Scientology committee of evidence. Well, Scientology's policy, which the courts have to call scripture, Scientology's policy does lay out the procedure for a committee of evidence. It doesn't lay out a procedure for an internal arbitration because there's never been any such thing as one. But Scientology policy does lay out the procedure for a committee of evidence. And because this procedure is dictated in policy, aka religious scripture, Scientology is saying that this entire process is a religious procedure, a religious ritual, and therefore the court cannot even get involved in whether it's fair or not, because that would require interpreting religious doctrine. So because Scientology has this fallback position of our internal arbitration is a religious ritual, it then begs the question, well, then isn't forcing a non-Scientologist to undergo your religious ritual a violation of their First Amendment right to leave Scientology? Fascinating question. Okay, it gets a little more interesting here. Upon review, the court finds that the issues presented by plaintiffs satisfy the standard. After considering the parties' position, the court finds that the 2 issues do involve controlling questions of pure law, which the appellate court can decide quickly and cleanly without having to study the record. Although the questions, I'm going to skip that paragraph. I love this paragraph here. The court also finds that there is substantial ground for difference of opinion as to these issues. The court emphasizes that it did not come to its decision to compel arbitration lightly or easily, and the controlling legal issues present difficult questions that have not been squarely addressed by the 11th Circuit or United States Supreme Court. God, I love that sentence. There is certainly room for disagreement, even if the court ultimately found defendants to have the stronger position. Finally, the court finds that interlocutory appeal may material advance. I feel like this word is being, I feel like it should say may materially advance the ultimate termination of the litigation. If the 11th Circuit hears the appeal and affirms, this case will remain stayed pending resolution of the arbitration proceedings. If the 11th Circuit reverses, holding that plaintiffs cannot be compelled to arbitrate, it will save the parties the expense and burden of arbitration, which may potentially take years, and allow the case to proceed to resolution in the district court. I love that sentence. Okay, it also says, in addition to considering the system-wide costs and benefits of allowing the appeal, including the impact that an appeal will have on other cases. I love that part as well. An interlocutory appeal may not only resolve this case, but also conserve judicial resources in the longer term by resolving important and oft-rising legal questions. Oh, I'm loving every word. The rest of this is probably not necessary. And then just for fun, what I wanted to share with you guys, I at least just wanted to show you the actual filing that's now been made with the 11th Circuit Court of Appeals to indeed asking them to review this. I believe the 11th Circuit Court of Appeals has to agree, but the official filing has been made. Let me see. Is there a date on this bad boy? I think this literally was just in the last couple of days. And bear with me while we scroll down to the relevant part. Dun, 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 dun. Table of this is going to be very brief, you guys. Believe me, we're not going through all this. There was just one part in here that I really liked. All right, let me just read this. Introduction. This case concerns whether plaintiffs, petitioners who fled and renounced Scientology after surviving human trafficking and forced labor must now be forced to participate in a dispute resolution proceeding conducted by Scientologists under Scientology policy. Although the district court found the trafficking and abuse alleged in petitioner's complaint surprising and shocking, it concluded that the law appears to require that petitioners submit to Scientology arbitration. Even where, as here, petitioners allege they were forced to sign the agreements, enforceable for 1 billion years, under duress. The district court then certified its order for interlocutory review, explaining that it did not reach its conclusion to compel arbitration lightly or easily. The controlling legal issues presented difficult questions that have not been squarely addressed by the 11th Circuit or the U.S. Supreme Court, and there is certainly room for disagreement. And, well, there we go. I'm kind of just repeating at this point what was already stated in the previous one. And you know what I'm going to do, guys? I am going to post links to both of these documents in the description down below, so that any of you who would like to pore over the more of the details of these have the opportunity to do so. Let me see. Is this interesting? Statement of facts. On April 28, 2022, petitioners Gwen and Laura Baxter and Valessa Paris, former members of Scientology, filed this lawsuit against several organizations within Scientology and its leader, David Miscavige, alleging violations of the Trafficking Victim Protection Reauthorization Act. That's still just a repeat of what we read earlier. Petitioners allege that when they were still minors, employees of Scientology forced them to join the Sea organization and provide unpaid labor and services to Scientology, including while aboard Scientology's cruise ship, the Freewinds. Petitioners allege that for the years they were assigned to work on the Freewinds and in the Sea Org, they endured highly dangerous and abusive conditions, often working between 16 and 24 hours per day for little or no pay. Petitioners allege they endured arbitrary punishment, humiliation, interrogation, imprisonment, and other acts of mental and physical and emotional abuse at the hands of Scientology. Initial order, Scientology also confiscated petitioners' passports and other documents to prevent them from escaping Scientology's abuse. Okay, I'll post the documents down below and people can review them. Just imagine a twisted legal system, a structure of prior legal rulings in other cases that would allow for Scientology to coerce minors to sign billion-year contracts and arbitration clauses that would prevent them in the future from being able to seek remedy in the courts for such abuses. That's why it was a real surprise, a disappointment that Thomas Barber ruled the way that he did. But at least nice to see that in his ruling, he said, look, this is unconscionable. But it does seem that based on the case law I'm forced to consider, it seems that this is the correct procedural decision to make. And this is probably a conversation I should have with my my lawyer friend, Zach, is I do personally have trouble understanding how the judge can go, this is how I think I'm supposed to rule. But I do agree it's something you should be able to ask the appeals court to overrule me on. I'm a little confused about all that. Like, I'm glad to see it, but I'm a little confused why it seems like Judge Thomas Barber felt he didn't have the authority to rule otherwise. Like, if it, but he does acknowledge that it's like a legally contentious issue that someone could easily disagree with. And I go, but if someone could easily disagree with it, why couldn't that someone have been you? Do you see what I mean? That's where I'm a little lost. So, okay, guys, that's it for this for right now. I'll post those documents below so you can check them out yourself. Thank you to everyone for watching. Thank you to everyone who watches until the very end, and I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.